Good evening to everyone. Let us start the discussion, which we have already progressed yesterday with regard to the public interest litigation, and the practical aspects and drafting portion is going to be discussed today. So I'm just sharing my screen. So yesterday we have discussed about the basics of public interest litigation, as we are not aware about a background of all the participants. Stretch that what is actually the important provision relating to the public interest litigation, how it has been developed by the judiciary, and then how it has been used now by many particular cases in many particular grants of the rights, and the list of the public interest litigation also we put in front of you, that the many cases are very successfully known as a savior of the fundamental rights, and these are the important provisions which are there. Now, as we came to conclusion, we discussed that it is one of the most significant development, and in 1980s, the judiciary has become the one of the torch bearer for the protection of the rights, and then they have very positively said that in case if there is no direct provision for protection of the right, we cannot be silent spectator, and we should grant some of the remedies, even though the affected person personally has not approached the honorable in a representative capacity if he is approaching the courts, that is the most particularly the higher judiciary, either under 226 to High Court or 32 to Supreme Court of India. Court will accept that petition, and then it will also help to reduce the multiple petitions and many more things. But as I told you one story, and then the story was identifying that nowadays it has a situation that the public interest litigations are used for some publicity, some private interest, sometimes political rivalry also, and sometimes therefore there is no need to give names here right now also, because time will not permit, but you just take care about the last interest litigation. It may be relating to EVM machine, it may be relating to the VVPAT machine, it may be relating to the reservation which was introduced by virtue of the constitutional amendment. It also may relating to the challenging the new criminal laws also, which are going to be implemented from 1st of July, and many more. Nowadays it has been shown that some people who are well-known, renowned social activists, or you can say the political party owner or something, or of the people, court has now got a strict view also, and therefore main challenge always that how far the particular person is serious, and therefore it is also some kind of guidelines, some kind of principle which should be drafted, which should come into surface, and therefore some of the efforts have been taken. So public interest litigation should not be only by clean hands, but also by clean heart, clean mind, and clean objective. This is what one of the important matter which has been spoken by the court, and therefore court will be flooded, and then the creation of areas of the cases will happen, because this is something wonderful written. You can see that no state had right to tell citizen that because of the large number of cases of the rich are pending in courts, we will not help the poor to come to the court for seeking justice. This cannot happen, and therefore there can be some mechanism. And this is the development which I concluded the discussion yesterday, that 2010 onwards, Supreme Court of India, Gujarat High Court, Bombay High Court, Guwahati High Court, Delhi High Court, and many High Court later on came with the guidelines. Now, this is something very interesting, that guidelines are already there in our country for proper drafting and for proper entertainment of the public interest litigation also. Now, these guidelines are followed by Supreme Court guidelines, and then there can be some of the points. So I have put some of the point here in the slide. Remaining point I am showing from the particular directly the guidelines only, which I will open on my screen. So directly addressing letter to the judges is now not in much practice. Earlier, when the PL relating drafting was not there, it was identified. Now it has been identified as a separate mechanism which is there in every court of law. So misuse of the particular political motives or private motives, a proper channel has been identified. Self-restraint concept I also yesterday explained, because generally when the petitions are filed before the court, Supreme Court or High Court, I'm sure in case some of you have attended the proceedings, or in case you are practicing, High Court always taken a view that come through proper channel, right? You might have heard. Suppose if I am a citizen of Ahmedabad city and I am going to Gujarat High Court by saying that, sir, Ahmedabad Municipal Corporation has not provided sufficient amount of, say for example, the garbage points so that the disposal of the waste can be made, and therefore I want to file a PIL. So court will suddenly tell, okay, why you are coming before us? Isn't it any mechanism created by Ahmedabad Municipal Corporation? Can't you go and file a complaint to mayor first? Can't you get the local relating machinery into work first? In case they are failing, then only come to us. So there is always a concept of proper channel. But in some of the grave cases, like we discuss custodial violence, right? And then we discuss about environmental protection, the water pollution, air pollution. In this kind of grave cases where the life of the person is directly in hazard, and court cannot tell you to wait in a proper channel because it may take some time. So some of the cases have been identified. So there is always a question that how courts are taking a call. So there's a discretion which is used by the judges to entertain the petition, and self-restraint also we discuss. So personal grievance versus public grievance, this also comes into picture. There's a very thin line between both of them. Person may also have personal grievance, but there should be a representative capacity on behalf of the public at large. Like suppose I am an owner of the flat, and just beneath my flat there is a water, open sewage water line. Now I cannot file a public interest litigation by telling that thousands of people are getting affected, whereas in my flat only 100 people are staying. So there can be a representation before the local authority, or there can be representation suit before the lower court, rather than granting a PIL in against the municipal corporation for a small matter which I am facing directly, which can be easily grievance. But suppose there is a big pollution thrown away into the water of the river, and then entire river get polluted, and lakhs of the people who are in same city are getting affected, obviously person will identify it as a public grievance. So there is always, now here there is no any direct guidelines, or there is no any direct kind of instructions. It is depending upon the creativity of advocates, and therefore I will request that in case you want to learn good thing about public interest litigation, sit in the court where PILs are filed, and in admissibility how the advocates are trying to convince the court that, sir, this is the matter relating to the public grievances. So that can give us the aspect. Some other challenges of the PIL is that there can be half-back information. Now, what do you mean by half-back information? I will give example that suppose one thing which is identified by a person, like I am a law student or I am a lawyer, and I want to file a PIL in court of law because some issue I have identified and I think it's one of the grave issue. Like take example that there is a problem of traffic on the road, right? All the roads are flooded with the traffic, and then I observe that police commissioner has not deputed proper number of police officers at the four roads. So there is a traffic jam always. The people are not taking care about the parking, and therefore I am going to file a PIL in a court of law that, sir, in this city there is an exorbitant amount of the traffic jam. There are multiple issues of traffic jam, and there is a complete failure of machinery. Now here court will ask that what is the latest knowledge about you, because similar kind of petitions would always be started. You must have heard that nowadays many high courts are taking suo motu actions. Like many high courts have, judges have taken some of the petitions suo motu. They already have initiated the inquiry. They have already given notice to the state. State government is already in a process to prepare the plan for widening the road, for making the separate parking plots, etc. In that case, I have not taken any pain to get the some of the information. I have not correct facts. I am not even qualified to raise the issue, and simply just because I have found identified some issue as a public relating issue of my own, I can't go to the court, right? So this is one of the important issue right now. Once upon a time when public interest litigations were less, this issue never came into picture, but nowadays many matters are filed, and please be very mindful. In case you go to high court, in many high court there is a separate bench which is constituted by the chief justice of the concerned high court, and they are taking care about the public interest litigation. Now keep in mind that in high court there are thousands of appeals, there are thousands of revision review appeals which have been filed because of the lower court decision. Now they are the regular jurisdictional cases, right? There are cases which have already filed before the court of law. Now entertaining public interest litigation is like there is a hospital, and then in a hospital there are 100 people sitting in a queue because they want to meet the doctor has so many patients in a line, and then there is a sudden accident case where a 108 emergency ambulance has rescued the person from the road, And here the person is not need to sit in a queue. He will be directly brought into the operation theater. He would be given immediate treatment, because that's a question of his life and death. PILs are entertained like that, like fundamental right violation cases. So even though normal cases are pending, court will tell them to be in a waiting situation, and court will entertain the petitions which are filed by virtue of the PIL. Now this information should be genuine. Otherwise, what will happen? That the people who are already not able to wait in a queue, they will also come in front of the court by filing public interest litigation. So there can be multiple issues which has now come on limelight. So today there is a challenge before the different courts about that, and therefore I told you that there are the notification. Now I will show the notification, which is the which copy I have downloaded, and I'm sharing that copy on yours on my screen once again. You can have a look to that. These are the uh, Gujarat High Court rules as well as the Supreme Court India guidelines. Supreme Court India guidelines are also there. I just have opened it. I'll see this. It is available to you. Even in Supreme Court of India rules, public interest litigation have been identified. It has been specifically mentioned. Yeah, it is. I hope that it is visible to you on your screen. Now see, this is the compilation of guidelines to be followed for entertaining letters or petition received in by virtue of the. So now there was a judgment by Supreme Court of India by full bench in 1st of December 1988, and therefore these are the guidelines. I don't know how many of you who have gone through that, minutely looking to the guidelines, and then I will share the actually filed PILs. So it has been mentioned here that no petition involving individual or personal matter shall be entertained as a PIL matter except as indicated hereinafter. So there is a clear bar, D bar, that any matter which is personally involved, which is not considered to be the public interest litigation, letter petition failing under following categories alone will ordinarily be entertained as a public interest litigation. Yeah, you can entertain the letter petition, but what are the things which are grave emergency matter, like bonded labor matters, which is already abolished, but when there is a particular observation by some of the person that in spite of there is a denial of bonded labor, it is mentioned, then a petition can be entertained. Neglected children, non-payment of minimum wages to the worker, or petition from jail, complaining harassment for premature release or seeking release after the completing 14 years in jail, death in jail, transfer. So this petition can be entertained as a letter petition which has been identified. Petitions for premature release, parole are not matter within deserve to be treated as a petition under Article 32, as they can be effectively dealt by the concerned High Court. To save the time, registry may simultaneously call the remark of the jail superintendent and ask him to forward the same to High Court. The main petition may be forwarded to the concerned High Court for the disposal in accordance with the law. Even in regard to the petition containing allegations against the jail authorities, there is no reason why it cannot be dealt with the High Court, but petitions complaining torture, custody death, and the like may be entertained by this court directly if the allegations are of the serious nature. So I hope you are able to see this guideline which I have opened. I am highlighting some of the point. Yeah. Yes, it is. I hope it is visible to you. Right. I hope it is visible, right? Okay, all right. Now, petition against police for refusing to register case, harassment by the police, that is also considered to be the PS petition. Petition against atrocities on women, in particular bride harassment, bride burning, rape, murder, kidnapping. These petitions will also be entertained as a letter petition and considered to be the public interest litigation also. Petitions complaining for harassment of the torture of the villagers by co-villager or by police from person belonging to scheduled caste and scheduled tribe or economically backward classes. These petitions are also considered to be the grave atrocity cases we can call in nutshell. Then petition pertaining to environmental pollution, disturbance of ecological balance, drugs, food adulteration, maintenance of the heritage and culture, antique forest, wildlife, and other matters public for importance. This also is considered to be the petition. Petition from riot victims. If there are some riot situation and then government has failed to take care about that, they are victims, then this petition will be there. Family pension, all letters petition received in PL cell will be first scanned. So this is the procedure which has been mentioned. Now here you can see that what petitions are not considered to be the public interest litigation. So following categories will not be entertained as a PIL, like landlord and tenant matter. service matter and those pertaining to pension and gratuity. Now see that service matter are relating to individual person. Like suppose I am working somewhere in government department as a section officer or deputy section officer, and then my pension has been withheld, my gratuity has been withheld. I cannot go and file a PIL. It may be regular service matter by virtue of the writ petition, which may be mandamus, which may be considered to be the certiorari or prohibition if it is a quasi-judicial authority concern. So this petition will not be considered as a public interest litigation. Complaint against central or state government department, local bodies, except those relating to item 1 to 10 above. So if any complaint is there, except for the matter which has been mentioned earlier, it will not be considered as a PL. Admission to medical and other educational institution is also not subject to PL, because admissions and for that different kind of the bodies have been constituted. So court has directed not to treat as a public interest litigation. Petition for early hearing of cases pending in High Court and subordinate courts. Also, again, it is not coming as a public interest litigation. In this regard, the petitions concerning the maintenance of the wife, children, and parents, the petition may be asked to file a petition under Section 125 of CRPC or a suit in court of competent jurisdiction, and for that purpose, approach the nearest legal aid committee for the legal advice. So, this is the guideline by Supreme Court of India. I hope it is possible to for you. Now, this is the Gujarat High Court rules. I told you that the same high rule are main part of the different High Court. Are you able to see the Gujarat High Court rules on your screen? Yes? Am I audible to you? Are you able to see the screen?
Yes, sir.
All right, all right. Please keep interacting so that I can get it. Okay. So that's the same rules which has been defined. Here, first time I told you that there is no definition of the public interest litigation in Indian Constitution. But here the guidelines have been mentioned that public interest litigation without limiting generality of the said expression shall mean a litigation undertaken for the purpose of redressing genuine, substantive or larger public injury or public grievance, or for enforcing any public duty, or for vindicating public interest, but shall not include a matter involving individual, personal, or private grievances of the petitioner or anyone else. So, this is the meaning of public interest litigation, which has been given in Gujarat High Court rules also. And then the standard rules are there that what should be the pro forma. And here the Gujarat High Court petition rule I am showing you because the same Supreme Court of India guidelines, the High Court of Gujarat also have come out, and this has been followed largely by everyone, that your petition should have this particular pro forma, that your local standing, professional status, who are you, your antecedents, then nature and extent of public interest of the petitioner if involved in the cause, how your public interest is involved, then whether the petitioner has ever faced contempt of court, because you must have heard that many times the courts are rejecting some of the faulty matters or petitions, and sometimes they are putting the lot of fine also for wasting the time of the court. So if any contempt petition has been filed, that should be mentioned very clearly. If not, you are writing that there is no contempt matter or contempt cases has been filed. Facts constituting the cause chronological order. If the petition is based on the news report, it must be stated whether the petitioner has taken step to verify the facts personally or not. Today we are in era of the AI and deep fake. So it is quite possible that news report or any kind of social media or any other news may not be verified because it is not considered direct evidence in a court of law. But sometime it is possible. Like I will give example what happened in 2011 in Gujarat. I will tell you that I am in Ahmedabad city, and therefore there is a east side of city and west side of city. East side of city means there is a Sabarmati river which is flowing or running in between the city. So eastern side of Sabarmati river and western side of Sabarmati river. So one fine morning, what happened that there is a newspaper, and this newspaper covered a story, and story was that there is a particular slum area which is on the western side of the city, and there the dirty water was there every time everywhere on the roads of the slum area, and people had to walk through the water, and the water was so chemical based that some of the people got a skin allergy, skin infection, and then their feet and their hands where clicks of the photo were visible, and their literally skin got allergy. Telling you that this petition, which was a public, sorry, yes, am I audible and visible now?
Yes, sir.
All
Both.
right. Okay. So this example is there. So sometime question is always asked that should you personally collect the data? Yes, answer is yes. And let me tell you that right to information application is sometime a wonderful source of information, that when you want to file a PIL, You can always collect the right information through filing RTA application to different department to see what is development, what action have been taken by government, what action has not been yet taken. And after compiling everything with the news report, you can always file the petition. But in case you are filing, you have to take the verify steps to verify that. Now, what is the nature of injury cause? That also you are writing. Then, in case of the petitioner's organization, the petition must be filed through an authorized office bearer of the organization concerned, disclosing the additional detail of the other public interest litigation previously filed by the same organization with case number, status, and case. Now, you must have heard about ADR. No, ADR, you might have heard. There is a wonderful, institution or organization working, Associate for Democratic Reform in India. I'm sure you might have heard. You just search on Google that petition filed by ADR. There is also Common Cause, right? So Common Cause, ADR, and then many NGOs are also there, which are working for the welfare of the people. They want to take justice available to the people, and therefore these kind of organizations can also file the petition. But here you have to take into consideration that this organizational petition should be through office bearer only, and also you have to mention everything: how many earlier petitions filed, what is the disposal, what is the judgment given, and then afterwards how you are claiming the relief by virtue of the new petition. So these all things are required to be mentioned. There is a mentioning about the rules which has been available. Then the petition shall contain a declaration that a petition is filed purely in public interest and not that the instance of any person or organization. This is going to be the declaration, and then estoppel will be applicable. So you cannot file simply petition to waste the time of the person. It should be properly in a public interest. That declaration is mentioned. Full detail of the source from the cost of the petition. There is a wonderful idea in our country. There is a maintenance and champerty contracts. I'm sure you might have heard in contract law that maintenance and champerty agreements, they are against public policy. Now, what is maintenance and champerty? Maintenance agreements are those kind of agreements where you are helping someone to take public, you can say public risk or recourse, or you can say take court action. So when someone is helping someone by virtue of giving money, and then the money will be used to take legal action, and then agreement that I will return the money, this is called maintenance agreement. And champerty agreements are those that suppose you are going to file a case and I am helping you with my money and telling you condition that whatever outcome will be there of the case, whatever amount you get at the end of the judgment, we will distribute the amount equally. This is called champerty agreement. So there is always a legal ban on this provision, that it has been stated that you should always fight the case of your own money. Sometime some people may fund the public interest litigation. You might have heard many times that some person who is unable to go to court will give a finance in order to create a distance or in order to create some of the problems and legal action. This is the source which is required. So in PL, always court is asking that what's the source of the cost? Are you paying from your pocket or you have collected money from someone else? The petition must further contain averments on how public interest is involved. How public interest is involved, that should be mentioned. The cause involved in purely public intent and constitutional or statutory provisions. So these are the things which are mentioned. I will share this particular guidelines with you. There's a rule, Delhi High Court also, you can see on your screen. I have almost every High Court's rule ready with me, and everywhere this is the wonderful initiation. Some of them are following the procedure, like what are the different formats. Every high court has come out with a different kind of the formats, pro forma, affidavit, etc. So as you see that in Delhi High Court they have come out with the pro forma, and then you are writing the same content in a different manner. So these are the examples. Now I will bring your attention to the actually file PILs, and then you can see on the screen there are multiple PILs which I got it, and I want to share that with you. Yeah, this is the PIL. All right. I have opened a couple of petitions, and when we discuss this thing together in a classroom, I always tell to my students that we read judgments of Supreme Court of India, different high courts, but then suppose you read the MC Mehta judgment. Now this MC Mehta judgment is already very wonderful when we read about that. But then imagine that petition which would have been drafted, which would have convinced the court of law. How fantastic drafting it would be. And therefore, this is the particular petition which I have opened in front of you. This is what a petition for special bench in respect of the uh, just 1 minute. Yeah. Okay, so you see this is the petition for gender equality. Now this is the this format is actually filed petition, so I got the copies of that, and you can see it's filed by the Ashwini Kumar Upadhyay petitioner versus Union of India, and see the topic and content of the petition. Who is a respondent? I am sure that you must be aware that whenever you are filing the writ petition, rules of CPC for joinder, non-joinder, and misjoinder of the parties are not strictly applicable for the petitions, writ petitions, right? You must have to take a note of that. That in writ petitions, joinder, non-joinder, and misjoinder things are not strictly followed. But yes, High Court is always expecting that whoever is there against whom you are getting a prayer should be joined as a party. So generally, when you are filing a writ petition for fundamental right, state is always a party against whom you have any grievance. One question is always asked, can you file a petition against the private parties? Answer is no. The direct private parties are not going to be part of the petition. But yes, you can join the private party along with the government officer or government department when they are also going to take action against the private party. Best example is the habeas corpus cases. There are multiple petitions which is there. Like suppose a husband and wife have lawfully married, and then suppose the family members of the wife have taken her back, and she has been away from the lawful custody of the husband. In that case, what is happening that husband is going to file a habeas corpus when her wife is not found, and even though she is going to lodge a police complaint, police will not entertain their complaint. Police will say it's a family matter, so why you are willing to waste our time? So in that case, habeas corpus petition, there is a tendency to involve the in-laws also, who may be considered to be the people who are private party. But this is again along with the state government. So police officer, state government, and then later on the private party. So in that way, private party's role is coming into petition. So that's an important point which you have to keep in mind for drafting petitions. All right. So this is one of the aspects which I told you. Now see here, most of the in petition you will find out that private parties would be not there directly. Union of India and Law Commission. And now see the subject matter of the petition. This is the synopsis part. So I am simply rushing this part or moving this part forward. Now see, this petition has been filed for seeking common minimum age for marriage. So as you know, that common minimum age for marriage is required to be fixed by court, and that's for the petitioner has approached. And then so many pages have been written, it's not possible to read, so I will share the copy with you. Number 2 is elephant petition. You must have seen this in Assam, where the railway line is passing through the forest, and many examples are there in which the elephants are crossing the railway line and they are getting completely killed. So this is the petition filed to protect the elephants basically from the railways only. So this petition, you can see the amendments, how many parties have been made. So Union of India, then Railway Board through Chairman, Ministry of Environmental and Forest, State of Orissa, State of West Bengal, State of Assam, State of Uttarakhand, State of Uttar Pradesh, State of Madhya Pradesh, State of Chhattisgarh, State of Tamil Nadu, State of Kerala, State of Karnataka, State of Jharkhand. All the states where these particular railway questions are there is party. Now see, whenever the opponent are state government, they are represented through secretary or proper authority which is there. Generally, they are secretary only, which are designated, and the summons and the notice will be served to them. So that's a nomenclature which is coming. Now you can see the content of the petition. That a petition under Article 32. Now why it is 32? You can see that the nature of the public interest litigation challenging the inaction of the Ministry of Environment and Forest, Indian Railways, and many state governments and their failure to protect the national wealth, like the elephants, which is ethnical anti-ethnical to Article 48A and 51 AG of the Constitution of India, Section 39 and Section 50 of the Wildlife Protection Act, and various provisions of the Indian Forest Act, Indian Penal Code, Forest Conservation Act, and Prevention of the Cruelty to Animal Act. So this entire petition has been drafted in this way. It's a wonderful petition. You will read it and you will get to know that how the applicant has convinced the court that this is the question of the public interest. There is a requirement to protect the national heritage, and if elephant, not only elephant, but many wild animal like including tigers, lions, when some hunting activities are going on, that can disbalance the ecosystem also, and therefore there should be proper action. So I'm bringing your attention to the final prayer clause. Many things have been written, and it would be great in case we will be able to read this petition. Now see what has been prayer, what has been cause of action and prayer. That most respectfully prayed that issue a writ of mandamus or other appropriate writ or order or direction directing respond number 1, 2, and 3 to initiate appropriate steps forward to prevent such train accidents killing elephant. Issue writ of mandamus to other appropriate writ order direction directing respond number 1, 2, and 3 to initiate appropriate action and pass necessary direction to prevent the accidents, and issue a writ of mandamus to other appropriate writ and against the respondent to take measure as to develop and enforce such procedure and mechanism to comply with the safety and protection of elephant. So this is one of the example. Second is a PIL for implementation of the Vishakha guidelines. Now you see, Law Commission report on hate speech. Law Commission of India 267 report came on hate speech. Hate speech has become one of the major issue right now. During the election time, you might have seen that many leaders, many people who are socially activists are found involved into hate speech. And then today, once upon a time, when something was spoken, it was remaining limited to rallies only. And most of the time, it will come in a government like Doordarshan, news item, etc., or it will be published in newspaper. But today, the moment some sentence or some things have been, some sentences are made, it become viral. There are a lot of reels, there are a lot of videos which are there on social media, and therefore this hate speech are becoming the reason for violence in many matters. There can be group violence, communal violence. So there is again a same petitioner, Ashwini Kumar Upadhyay, and then this petition has been filed under 32 that there is a implementation of the recommendation of the Law Commission of India has been made. So this entire petition has been filed. Read this particular content whenever you are getting time, how it has been mentioned there. Third is about the mob lynching, targeted lynching. There is one petition. This is filed by Mr. Tushar Gandhi. You must be knowing. It's a very popular, person. And then it is against Union of India and State of Uttar Pradesh, State of Haryana, State of Gujarat, Jharkhand, Rajasthan, Jammu Kashmir, Karnataka, Madhya Pradesh, all states wherever the targeted lynching aspect have been there. And see the content. All the respondents are contesting respondent petition seeking assurance of the specific guidelines in respect of the targeted lynching. Now, what is targeted lynching? How it is happening? There are very brutal cases have been identified. That how Article 21, Article 14, Article 9 rights will be granted, and then how it has been violated by the targeted lynching. So this petition is also converted into public interest litigation. Court concluded that that should be the guidelines, and ultimately, in many matters of targeted lynching, mob lynching, courts are there. Must for your kind information, the new IPC, which is called Bharatiya Nyaya Sanhita, have a specific provision under section 104, 106, 101, 103, which is talking about the group or targeted lynching. Also, mob lynching word has not been used, but it has been mentioned that when a group of people have committed the murder, each of the members shall be deemed to be the culprit, and actions will be taken. So this is one of the example that how Targeted lynching, mob lynching would convert into violation of the fundamental right. Now, this amendments, this petition I am also sharing because you see the very basic introduction. I am reading one two paragraph. It will be very interesting. The present petition is under Article 32 of Constitution, being filed by the petitioner to enforce fundamental right. Petitioner is a public spirited individual and in the great grandson of Mahatma Gandhi, father of nation. So Mr. Tushar Gandhi, as I told you, very popular personality, great grandson of Mahatma Gandhi, have come out with the petition. Petitioner is a deep believer in the life, philosophy, and teaching of Bapu. He has endeavored throughout his life to promote the life teachings of Bapu, share the value of justice, kindness. Now, what is the current? The petitioner is citizen of India, working as a writer consultant with the annual income of about 8 lakh rupees per annum, residing at so and so address, and then the petitioner does not have any personal interest or any personal gain or private motive or any other oblique reason in filing this writ petition in public interest. The petitioner has not been involved in any other civil or criminal revenue litigation which could have legal nexus with the issues involved in the present petition. Respond number one is Union of India, and then identification about all the respondent. And some of the grounds are very interesting here in this case. There are the facts which has been mentioned in para number 28 onwards, that how Indian constitution is there. But then there is a pattern visible of these incidents of lynching, extrajudicial murders when members of the religious minorities, particularly Muslims, oppressed caste group, Dalits have primarily been targets. Many of these lynching have been carried out by the vigilant group which are engaged in illegal actions on the name of the cow protection. So this is one of the petition which has been filed. The Dadri Akhlaq case is become very popular. In Maharashtra also the lynching issue came. So this is petition. I will share this copy also with you in case you not have read. Have a look to that. Then this is again one more petition, again filed in Supreme Court of India about the Rohingya refugees. You have there is always a discussion on the Rohingya refugees from Myanmar, and then whenever refugees were there, the governments were not ready to keep them. So this petition has been filed. Jaffarullah and other versus Union of India respondent, and this petition is also very interesting, having the idea that fundamental right of life and liberty, and how the Rohingya refugees should not be, subject to the atrocities and cruelty, and human treatment should be given. So this is the main target of the petition. So this is the name, Jafar Ullah and Abdul Quddus versus Union of India, NCT of Delhi, NCT of Delhi, and Haryana. And this is the content. You can see that petition, which is for respect of the displacement. So read the article first, any paragraph. That present writ petition is being filed in public interest under 32, relating to serious violation of the right to life, mental health, the right to health, and the right to basic human dignity of women and families from Myanmar who have suffered persecution, violence, and displacement, and now live in the deplorable condition in makeshift camps of Kalin Kunj, New Delhi, and Salheri village, Mewar district, Haryana. Women deliver in the camp without adequate care, shacks, and infected camp in Delhi and killed small baby boy. Women feel threatened of the Haryana camp. Now see here, there is an interesting point that Article 20 and 21 is including the word person, right? I discussed this yesterday. The 19 is available for citizen, but 21 use the word person. And therefore, even though person may not be Indian citizen, is entitled for getting the fundamental right protection from atrocities. This is very beautifully drafted in this petition. So this petition is also filed in PIL, in form of the PIL. Because of the paucity of the time, I am not reading, but I will share this all with sir, and you can read this content of the petition. Now this is one more petition which is again for disabled friendly footpath. Now you might have seen that now in a country, all government buildings department have ramp, on which now we are not using the word disabled, we are using the word specially abled. But till many years it was not there, and therefore this is the petition. Read the subject matter and content. Okay, so this is the petition which is filed with regard to disabled friendly. Now see, this is the big title. Writ petition under Article 226 of the Constitution of India, seeking a writ of mandamus or any other to direct the respondent herein to construct and maintain footpaths in the area of Delhi and NCR region, seeking a writ of direction in the nature of the writ of mandamus or any other writ in the similar nature be issued to the respondent for the enforcement of the right of all citizens under the Constitution of India and rights of the Person with Disability Act 2016 for the construction of the footpath and pathways to provide for unhindered accessibility to the road and other public places and to remove blockade, if any, due to encroachment or lack of maintenance which may act in hindrance in the free movement of the citizen, and direct all respondent to pass necessary direction. You must have seen this petition have been entertained by the Supreme Court, and many High Court have also entertained. Today, government departments have created the specially able person friendly access point. So, along with the staircase, there would be ramp where they will be able to walk. If they are blind, they will be able to walk with the stick. If they are unable to walk, then they can use the wheelchair. This all has been there. So, see, one petition which has been filed can result into lot of this petition was filed once upon a time, but what now got obsolete. Why? Because this is petition for the live streaming. Now this content is very interesting. Read petition 32 for enforcement of the public interest in front of guaranteed under part 2 or part 3 of Indian Constitution, and this is about the live streaming. Now I will simply bring your attention to the prayer of this petition. Issue writ order or direction in Supreme Court case proceedings of the constitutional and national importance having impact on the public at large on a large number of persons shall be live streamed in a manner that it is accessible to the public of viewing. Issue a writ of mandamus or direction in respond number 1 representing Chief Justice and judges of the Supreme Court to frame the guidelines that enable determination of the cases as cases of the constitutional and national importance. So before COVID, this petition was filed before the court of law, that whenever any matter is heard in a court of law, why general public is not getting access, so it should be live streamed. Fortunately, after COVID, court started working online, and today I am sure that you might be able to watch the court content and court matters in a live streaming matter also. So this petition is also positively read. And then one more last petition you can see, petition for Yamuna River. As we have seen that MC Mehta cases are already there, which has been discussed, and in many of the cases the judgment has been passed in order against the particular, you can say, the authorities which are emitting the waste and effluent into the water. But this is one more petition which has been filed against Delhi government under 226, that the river Yamuna should be staved by stopping destructive activity to the Yamuna river bed. So as you know, today only there was an interesting news that the ground level water has reached to very disastrous level, and there is a scarcity of the water. So what rivers are natural resources, and the days are coming. I'm in Gujarat today. It's a 41-degree temperature outside right now at 7 o'clock also. I have to sit inside the AC room, otherwise I won't be able to deliver. This summer is one of the hottest summer, we can say. So day by day, environmental changes are there, and therefore river protection is becoming the important. Although there are wonderful judgments by which court has given direction, still people have not created a situation where the rivers and water can be protected. So this entire petition of 53 pages is drafted how the river is very much important, what fundamental right will be violated, what actions can be taken, and everything together, which has been very specifically mentioned in the petition. As so I will bring your attention to the particular prayer clause only, you can see that, but other remaining portions are also importantly available. So you can see these are the prayer clause which I am putting in front of you here. That in view of the facts and circumstances, most particularly, most respectfully prayed that directing the respondent to remove construction, fill up the digging, etc., so far restore the ecology of Yamuna river bed. Directing Yamuna river bed in Delhi ecological sensitive area and hence to be protected and preserved. Directing that any construction in Yamuna river bed will permanently destroy the ecology of river, its groundwater rechargeability, doctrine, precautionary principle which are part of Article 21, directing that the respondent should locate alternative site for projects pointed out in EAC recommendation, directing setting aside EC dated 14th of December being violative of Article 21, directing setting aside EC dated to so and so as being arbitrarily directing the polluter pay principle and pass any order. So there are multiple cases which are there. I have couple of cases also, or petitions also. Like this is one more petition which is relating to tribal matter. The tribal life violation is available on a larger side. It should be protected. And there is a petition with regard to the medical termination of the pregnancy act and the use of or misuse of the provisions of that. So some of the drafts are there. This is one last petition which I would file, or which I will show you, that this was in the year 2018 for enforcement of the Vishaka guidelines. This is by Women Cinema Collective and other versus State of Kerala, and grievance redressal mechanism against sexual harassment. As per the Vishaka guidelines, that petition was filed, and ultimately it was taken by the court as a PIL, and then court is passed the order also. So there are few examples and multiple petitions. I have compilation of the particular matters which I have brought in front of you. Many of you who are practicing advocate would have the knowledge about that, and therefore you might have read it. In case you have not read it, you can always bring it together. One more petition is also there which I am sharing in front of you. It's not a read petition by virtue of PL, but normal petition which is against the odd even scheme of Delhi. I'm sure you might have heard about the odd and even scheme of Delhi, that on odd day and on one day odd number of car will be on the road, and on one day even number will be there. So this scheme was held to be completely violative of the rights, and therefore restriction of the use. So this is also a petition which has been filed by some of the person, in which very properly categorically identified that how this rule is turned out to be arbitrary and how the rights will get violated. So this is some of the petition relating to 2019, etc. So I will share this all petitions draft with you, and you can always read, and you can always you can say let me know. So I think time is not permitting us to go more. So these are the some of the aspects which I wanted to discuss with you. You can simply identify the case and you can. Yeah, in case of the context present in Jammu and Kashmir, what is the importance of PL relating to AFSPA? Yeah, I think recent development is there. When before the abrogation of Article 370, AFSPA and the many atrocities were already brought to the notice of the court by virtue of the various petition. Recently, after, I think, in case you are aware, that government held out that after the constitutional, as you can say, legislative assembly elections, the AFSPA will be removed, and then this news came because once the Ladakh Union Territory and Jammu and Kashmir as a state, no, so that is there. But still, in case of atrocities, petitions are maintainable. Now the special status has been not there, so Supreme Court is not able to identify that it is not relevant. Earlier, it was a situation that because of the special status, because of the many special threats, the Armed Forces Special Powers Act were implemented, and that's what court have restricted to enter in. But now, after abrogation, even though it has been very important for the protection of the civil rights, so that is also an important aspect right now. So read this, and as again I told you that very sorry we are not identified because all of the participants, I don't know everyone is law student or not, and therefore we have seen a broad overall aspect. But suppose if you want any specific kind of the discussion, we can always make it. But as Dr. Kalpesh Kumar Gupta and sir informed me about the students, this is the thing. My question is whether PL is a consistent with the concept of separation of power. Yes, yes. See, it's a wonderful idea. In doctrine of separation of power, in case you read Article 50, separation of power is between whom? You will find out that doctrine of separation of power will be maintained. Who will be subject matter of the separation of power? Yeah, can you tell me? Article 50 provides for separation of power between what wings? Yeah. Can anyone unmute and tell me,
Yes,
please?
sir. Between executive and the legislative.
Yes,
Executive and judiciary, sir.
yes. There shall be. It has been very properly mentioned. States shall take steps to separate judiciary from the executive of the public service. Right. So see, Article 50 has already been very importantly mentioned that judiciary is different and executives are different. Now, why legislature word has not been used? That's something interesting. That legislature is something very magical thing. That before election of the prime minister, it's a legislature. But the moment legislature has elected prime minister, the prime minister become the executive head, and therefore mostly the lawmaking and law enforcement is a task of executive only, and that should be according to that only. But because I the example of the PIL, if you minutely observe, court has categorically identified that the executive have very disastrously failed to protect the public interest, and therefore court has taken this call into their hand, and this has developed as a new jurisprudence in India. You are absolutely correct, and even constitutional mandates are there. But Article 50 has been read along with Article 32 and Article 20, and it has been identified that where the Article 50 is a part of the directive principle of the state policy, fundamental rights are far more better and enforceable. So, court has given priority to the fundamental right, and therefore this separation of power is not directly coming when these PILs are coming into picture. Yeah, role of legal aid is wonderful road. I'll tell you that in GNLU also we have filed two PILs. One PIL is filed by one of the student. He's from Assam. That in right to education relating laws were already there, but then ultimately this right to education was not available to some of the people. So legal aid, the students who are part of the legal aid can always file RTI, can always get the idea, and can always approach the people who are deprived of their rights in spite of the policy, in spite of the legal provisions. And then you can always approach the proper channel. But when you are not able to get proper answer, there's a delay, there is a lacuna, there is a completely non-performance by the government. After filing different kind of the petition, if you are not getting answer, PL is a best option, and therefore many PLs are also filed by on virtue of the legal aid it is granted by the people. PL is different from the traditional litigation. I think we discussed this point yesterday. Again, I will repeat. The traditional litigation is very categorically under the CPC as well as CRPC. CPC talks about the civil suit, which has stages. You go to lower court first, then you can go to high court only by virtue of appeal, review, revision. But suppose this much time you don't have, and then there is a question of the fundamental right, then courts have taken public interest litigation as a special vehicle where you don't have to wait in a normal lower court till your time comes. There is no need to appreciate the evidences because this is not a dispute between two people. This is the direct dispute between you and state, and therefore it is a relaxation of the word locus standi. I will share my presentation with you in which I have explained this yesterday, that lower traditional litigation follow the rule of locus standi, and public interest litigation is a relaxation of the locus standi. So even though you are not directly connected, affected, you can definitely go to the court, and your court will be able to entertain your matter. Right? So any other query, question? I will share this all submission. I am sure you would like to read this petition. I'm sorry, I have to run very fast. How many of you would like to read this petition which I shared with you? Can I get some response in a chat box, please? If you are not able to open your mic and tell me, yeah. Otherwise, it will be futile exercise, right? In case you are not able to read, it won't work. Say yes if you want this particular presentation as well as the petition which I shared with you. How many of you want these petitions to read? Because knowledge is power. You cannot draft the petition. Technically, we are understanding. I will tell you with a great responsibility. Learning law is a 10%, implementing law is a 90%. You can read, you can learn everything about PIL. But suppose there's a glittering issue, you are facing some problem, and if you will draft one PIL and if you will go to the court, that is 90%, and therefore this subject is discussed with you. And you don't have to simply listen to this, which may take a very a separate thing. It may be for a knowledge enhancement, but best option will come when you are actually implementing that. So in case you are willing to write a PL, draft a PL, read the very properly drafted PL, read the judgment, and I'm sure it will be helpful. I'm very much thankful that you invited me and you gave me opportunity to discuss. Many more things will be there. I am also heading Pro Bono Club at the Gujarat National University. So sir, we can always plan to have collaborative program in future also, where Pro Bono Club of GNLE would be very happy to have some of the programs, mutual interaction between the students, and we can always see what are the possible things for the legal aid in our country, sir. Yeah, thank you.